Today we are going to be looking at the area of tort law and in particular the law of negligence. A tort is a wrong resulting from a breach of civil duty. Early in the development of the common law system drew a distinction between two types of wrong. Wrongs of a general kind that were in fact crimes against society or the king. This developed into the area of criminal law, the object of which is to punish an offender, and personal wrongs that were left to be resolved by the parties themselves. This second area, now known as civil law, includes contract law and tort law. Unlike criminal law, the primary object of actions in civil law is to compensate the injured party and not to punish the defendant. Tort law was created by the common law courts to provide redress for general civil wrongs arising out of situations not necessarily covered by contract. Under tort law, a person who has committed a civil wrong may be sued by any person who has suffered damage or loss as a result of the tortious act. The damage may be caused to either a person or to their property. The common law recognizes three main types of tort. The first, non-intentional torts. In the case of non-intentional torts, it is not necessary to prove that the defendant actually intended to cause the harm suffered by the plaintiff or complainant. The second, intentional torts. In the case of intentional torts, it is necessary that the tortfeasor actually intended to do the tortious act. It is not necessary to show an intention to harm the plaintiff or that the tortfeasor intended the plaintiff to suffer loss. Thirdly, strict liability torts. Strict liability torts concern inherently dangerous objects or activities, for example, owning a factory that makes bombs or keeping a vicious dog on one's property. In such cases, the owner may be held strictly liable for all harm resulting from such activities, independent of whether he was negligent or intended the consequences. Now let's look more closely at the area of non-intentional torts, and in particular the law of negligence. Negligence is said to involve any kind of behavior whereby one party non-intentionally causes loss to another by acting without reasonable care for their safety. Negligence applies to any type of negligent behavior, for example, a person driving a car too quickly. The law of negligence was developed by the courts in the celebrated case of Donoghue and Stevenson. In this case, the plaintiff was in a pub with a friend. The plaintiff's friend bought the plaintiff a fizzy drink. The drink came in an opaque brown glass bottle, and consequently, the plaintiff was unable to see the actual contents of the bottle. The plaintiff drank the ginger ale and found a decomposed snail at the bottom of the drink, after which she became ill. The plaintiff could not sue the owner of the bar or the manufacturer of the drink in contract law, as she had not actually bought the drink. It had been given it to her by her friend, and consequently she had no privity of contract. As a result, she sued the manufacturer in tort, asking the court to recognize a new area of tort law based on the negligence of the manufacturer. In an important decision, the court considered that a manufacturer owed a duty of care to all people or classes of people that he could or should reasonably foresee as coming into contact with his products. As a result, although the plaintiff had no actual contractual relationship with the manufacturer, the latter nonetheless was held to owe her a duty of care, and, since he had failed in that duty by allowing a decomposed snail into the plaintiff's drink, the plaintiff had a right to damages for any loss occasioned by this negligence. According to the court, commenting on the general scope of the duty of care principle, the court said, "You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbour. Who then is my neighbour? The answer seems to be persons who are so closely and directly affected by my act that I ought reasonably to have them in my contemplation as being so affected when I am directing my mind to the acts or omissions which are called into question. Thus, in order to succeed in a negligence action, it is necessary for the plaintiff to prove a number of things, namely, the existence of a duty of care. The first thing that must be demonstrated when bringing an action in negligence is that there is an actual duty of care owed by the alleged negligent party to the victim. Secondly, breach of the duty of care. Once it is established that there is an actual duty of care between the parties, the question of whether the duty of care has been breached is decided by reference to the test of the reasonable man. Actual damage suffered. Once Y has established the existence of a duty of care and that the duty was breached by X, it is necessary that Y show that actual injury or loss resulted from X's behaviour. In tort law, a person will only be compensated for loss actually suffered. And finally, causation and remoteness. Finally, it is necessary to show a sufficient causal link between the loss and X's behaviour, and that this link is not too remote. Now let's look at the burden of proof and the notion of res ipsa loquitur that applies in the case of negligence actions. Where the duty owed by one party to another is self-evident and cannot be denied, the rule res ipsa loquitur applies. As we have seen, the burden of proof is normally on the claimant to prove that the defendant owed the plaintiff a duty of care. However, under the res ipsa loquitur rule, where the element causing the damage is shown to be under the control of the defendant, and where the accident is something that does not normally occur if those who have control of the element take proper care, it will be for the defendant and not the claimant to demonstrate that the accident did not result from his negligence. In this way, the burden of proof is shifted from the claimant to the defendant, who must demonstrate that he was not responsible for the loss suffered by the plaintiff. What do we mean by the notion of contributory negligence? If it can be shown that the loss or harm would have been less serious if the claimant had not contributed to it by his own negligence, the liability of the defendant to the plaintiff may be reduced. This is referred to as the notion of contributory negligence or comparative negligence. For example, Y accepts a lift from X in his car. Upon entering the car, Y refuses to comply with X's suggestion that he attach his safety belt, and thereafter X, who drives negligently, has an accident resulting in Y suffering injury. Y may have a cause of action in negligence against X. However, the amount of damages Y will receive could be reduced in proportion to the contribution he made to the loss as a result of his refusal to wear a safety belt. Originally, proof of contributory negligence worked as an absolute bar to the recovery of damages, and continues to do so in some common law jurisdictions. Other common law jurisdictions have adopted a modified system of contributory negligence, whereby the plaintiff's negligence only acts as a bar to the recovery of loss if he contributed to over 50% of the damage resulting from the accident. Other jurisdictions apply a system of comparative negligence, whereby the amount of the injured party's compensation is based on a comparison between the negligent conduct of the defendant and that of the plaintiff, one set off against the other. The formula for making this comparative calculation can be quite complicated, to say the least. Now, let's look at the area of statutory torts. Although the area of non-intentional torts is dominated by case law of the common law courts, the legislative power in most common law countries has also created statutory torts concerning areas such as product liability, occupier's liability, or employer's liability. Thus, manufacturers of products intended for public use are strictly liable for any defects in their products. In the same way, occupiers of land owe a clearly defined duty of care to people who come onto their land, and employers will normally be vicariously liable for damage caused by their employees. The law on product liability results from an EU directive in this area that has been implemented into UK national law. Indeed, tort law is a good example of how the United Kingdom's common law system, as a result of its membership of the European Union, is taking on characteristics normally associated with the civil law, i.e., an increasing emphasis is being placed on written law, necessarily leading to a reduction in the role of judge-made law. We hope you enjoyed this introduction to the area of tort law, and in particular the law of negligence.